Good afternoon. It's a great pleasure to welcome you to the 2015 Nora and Edward Ryerson lecture. This, of course, is an important university tradition since 1974 when John Hope Franklin gave the first of these lectures. There's been a lecture every year since then. This is a particularly important series for the University of Chicago because this is one of the a few times when the faculty of the university choose one of their own to deliver these lectures. And when you look at the history of the people who have been chosen, you see a remarkable summary of a significant part of the intellectual history of the university over the last 4 decades. This series is made possible by a bequest to the university from Edward Ryerson, who was a trustee and life trustee from 1923 to 1971. This is just one part of the Ryerson family connection to the university. Martin Ryerson was a trustee of the university from the very beginning. Members of the Ryerson family have been deeply involved in the university, and we're very happy to have Trustee Emeritus George Ranney here as another in a line of trustees from this family. One of the features that I described about these lectures about the singular nature of these lectures led Hannah Gray to refer to this as an occasion that celebrates above all the quality, the distinction, the contribution, and the collegiality of our faculty. For those of you who have been faculty members for a long time, you certainly recognize quality, distinction, and contribution, and most often collegiality. This year's Ryerson lecture is, of course, as you all know, Geoffrey Stone, the Edward H. Levi Distinguished Service Professor of Law. So Jeff graduated from our law school in 1971, joined the faculty in 1973 after serving as a law clerk to Supreme Court Justice William J. Brennan. He's a fellow of the American Academy of Arts and Sciences, member of the American Law Institute, the National Advisory Council of the American Civil Liberties Union, and the American Philosophical Society. He is, of course, a very distinguished scholar of constitutional law, in particular the First Amendment. He's been an enormously important citizen of the University of Chicago, as you all know, serving as Dean of Law School and as Provost of the university. More than that, he has been someone who has been extremely forceful and consistent in his commitment to free expression at the university and to the creation, establishment, and sustenance of an environment that's conducive, maximally conducive to the open discourse that lies at the foundation of the university. It was this evident, long-standing commitment that, in fact, led Eric Isaacs and I to ask Jeff to chair a committee on free expression, to create a statement about free expression for the University of Chicago, which we felt was particularly important during this particular time when, in fact, free expression is something that is, I would say, under some significant threat in universities as a whole. And it was, I would say, typical of Jeff's commitment that he worked with the other members of the committee to produce what I view as an extraordinarily important and a statement of lasting value for the University of Chicago and for other universities if they are wise to follow our lead. In any case, it gives me great pleasure, both professional and personal, because as many of you know, I worked with Jeff for a long time. Great pleasure to welcome Jeff Stone.
Thank you, Bob. I am truly honored to have the privilege of delivering the 2015 Ryerson Lecture, and I'm deeply grateful to my colleagues on the faculty for giving me this extraordinary opportunity. One measure of my longevity at the University of Chicago is that I attended the very first Ryerson Lecture by John Hope Franklin in 1974, and that I personally know or knew every one of the 42 distinguished scholars and teachers who've had the privilege of giving this lecture before me tonight. So you can imagine my feelings of both happiness and awe at this moment. Thinking about that history led me to think back about how I came to this point in my life. Back in 1968, I was a senior at the University of Pennsylvania. The nation's draft laws then allowed one final year of graduate deferment. And not willing to pass that up, I decided to go to law school because I'd been advised that even a year of law school would stand me in good stead before I had to decide whether to go to Vietnam or Canada. But that left the question of where should I go to law school? And at that time, I had a girlfriend with whom I had had a long-distance relationship. She decided to transfer to Northwestern. And so I figured, well, what the hell, I might as well go to Chicago, because that way we could spend my last year of freedom together. The night before I left my home in New York to drive out to Chicago to join her and to begin my legal education, she called and broke up with me. Needless to say, my arrival at the University of Chicago was less than joyous. But in the end, things obviously turned out okay. And so here I stand, all because of her, poised to deliver the university's Ryerson lecture. I am a great believer in the value of serendipity. So according to the terms of the Ryerson lecture, the person delivering the talk is, quote, asked to reflect on his or her intellectual life and work. And in reflecting on that charge, I considered several possible topics, but settled on my subject this afternoon because it derives from a book that I think I am completing, titled Sexing the Constitution, which examines the history of sex, religion, law, and the American Constitution. More specifically, and for obvious reasons of timeliness, I decided to focus this afternoon on the issue of same-sex marriage. Okay, so in August 1982, an Atlanta police officer went to the home of Michael Hardwick to serve an arrest warrant for public drinking. Upon entering the home, the officer observed Hardwick and another man engaged in oral sex. The officer placed both men under arrest for the crime of sodomy. In Bowers versus Hardwick, decided in 1986, the Supreme Court of the United States held that Georgia's prohibition of homosexual sodomy was consistent with the Constitution of the United States. Noting that the Constitution says nothing about a right to commit sodomy, and that proscriptions against sodomy have, quote, ancient roots, Justice Byron White, who wrote the majority opinion, concluded that to claim that the Constitution protects a right to engage in such conduct is, at best, facetious. In a concurring opinion, Chief Justice Warren Burger added that condemnation of homosexual conduct is firmly rooted in Judeo-Christian moral and ethical standards, and that to hold that the act of homosexual sodomy was somehow protected by the Constitution would be, quote, to set aside millennia of moral teaching. Justice Harry Blackmun, joined by Justices Brennan, Marshall, and Stevens, dissented. Although conceding that traditional Judeo-Christian values had prescribed homosexual intimacy for hundreds, if not thousands of years, Blackmun insisted that that fact cannot provide an adequate justification in itself for the Georgia law. That certain religious groups condemn the behavior at issue, he reasoned, gives the state no license to impose their judgments on the entire citizenry. To the contrary, he said, the legitimacy of secular legislation depends on whether the state can advance some justification for its law beyond its conformity to religious doctrine. Finding no such justification, Blackmun concluded that the Georgia statute could not be reconciled with the United States Constitution. But that, however, was a dissenting opinion. The court's invocation of moral and particularly religious prescriptions against homosexuality played a central role in the justice's reasoning in Bowers v. Hardwick, and is therefore useful to have some understanding of that history. So let's take a look at the ancient roots that Justice White invoked. The pre-Christian world generally thought of sex as a positive part of human nature. It did not see sex as bound up with questions of sin or religion. The ancient Greeks, for example, focused not on sexual sin, but on whether the individual's conduct was harmful to others. This extended even to homosexuality. Indeed, a common feature of classical Greek sexual life was that adult men often had sexual relationships with adolescent boys. This might seem strange to us, but Greek poetry, history, and literature celebrated such relationships and identified them with love, honesty, integrity, honor, and courage. Similarly, although Roman sexual life was different from that of the Greeks, the Romans too celebrated sexual pleasure, and neither Roman religion nor Roman law condemned same-sex sex. The emergence of Christianity, however, produced a profound change in the prevailing understandings of sex generally. By the end of the 5th century, Christianity had come to condemn sexual desire as inherently shameful and as an evil temptation that must be suppressed. This shift occurred over the course of several centuries, but it was Augustine who finally crystallized the early Christian understandings of sex. In a critical leap, Augustine linked sexual desire to the fall of man. Adam's transgression, he argued, had not been one of disobedience, as the ancient Hebrews had believed, but one of sex. Augustine therefore maintained that every sexual desire is born out of evil, that every child born out of evil is born into sin, and that it is through sex that man passes on the original sin from one generation to the next. Augustine therefore concluded that man's only hope for redemption lay in repudiating the sexual impulse, and with it the burden of sin and shame inherited from Adam. Augustine's vision ultimately shaped the future, not only of Christianity, but of Western culture and law more generally. During the next 1,000 years, Christian dogma, backed by the threat of hellfire and damnation, attained not only religious, but also social, political, and legal authority. The sin of sodomy came to be seen as uniquely dire. For as the biblical story of Sodom had taught, for this particular sin, God will punish not only the sinner, but also those who failed to prevent the sin. It was still unclear, though, precisely what acts constituted sodomy. It was Thomas Aquinas who, in the 13th century, first drew a sharp distinction between opposite sex and same-sex unnatural acts. Although oral or anal sex with a person of the opposite sex was deemed a vice against nature and to be taken seriously, such acts with a person of the same sex, he concluded, constituted the worst form of sodomy. Before long, Thomas's thinking on this point became the dominant authority in Christian doctrine. At roughly the same time, and not coincidentally, same-sex sex came for the first time to be declared not only a sin, but a crime. That is, the Church, for the first time, conscripted the secular law to extend its prohibition on same-sex sex not only to those who shared the faith, but to everyone, regardless of their personal and religious beliefs. Criminal statutes against same-sex sex were thus enacted throughout Europe. And because of the heinous nature of the crime, these laws called for homosexuals to be castrated, dismembered, burned at the stake, drowned, hanged, stoned to death, decapitated, or buried alive. In short, homosexuals for the first time became the object of a systematic program of extermination. Although the Reformation brought about significant changes in the Protestant attitude towards sex generally, those changes did not extend to homosexuality. To the contrary, Protestant reformers reaffirmed in no uncertain terms the traditional condemnation of homosexuality as a detestable and abominable sin. In the American colonies, for example, the Puritans declared that sodomy must be punished with death without mercy. And they warned that the land cannot be cleansed until it had spewed out this unclean beast. By the time of the American Revolution, the colonies, under the influence of the Enlightenment, had pretty much stopped using the criminal law to prosecute most forms of consensual sex, except for the crime of sodomy, which remained a capital offense. Indeed, sodomy remained a serious felony in every state in the nation for the next 200 years. Now, throughout all of this history, until the late 19th century, it was generally assumed that individuals who chose to engage in same-sex sex were no different from other individuals who chose to engage in other types of sinful or criminal behavior. Engaging in homosexual sex, like engaging in assault or robbery, was simply a choice. This assumption began to be questioned, however, in the late 19th century, as medical authorities became interested in the issue. For the first time, persons drawn to same-sex sex began to be seen as individuals possessed of a distinctive psychological identity. It was in this era that the concept of the homosexual first came into being. Leading studies of homosexuality in the late 19th century posited that homosexuality was a pathology, and that persons afflicted with this pathology were strange freaks of nature. Among the questions debated were whether the inclination to engage in homosexual conduct was congenital or acquired, whether it was curable or incurable, and whether it should be accepted as an unavoidable condition or actively resisted and suppressed. Physicians in this era proposed a broad range of remedies for homosexuality, including hypnosis, psychoanalysis, sex with prostitutes, intense bicycle riding, rectal massage, burning the neck and lower back with hot irons or chemicals, electric stimulation, castration, and clitorectomy. Many doctors recommended the sterilization of homosexuals in order to prevent the condition from being passed on to the next generation. And by 1938, 32 states had enacted compulsory sterilization laws aimed at homosexuals. Also in the 1930s, the image of the homosexual in the United States took on an increasingly sinister cast. A growing public anxiety over sex crimes recast the dominant image of the homosexual as a dangerous psychopath who is naturally inclined to commit the most unspeakable crimes against others. Demonized not only as perverts, but now as child molesters as well, homosexuals became the new enemy of the people, and arrests for sodomy increased dramatically in the 1930s. During World War II, the United States, for the first time, attempted to prevent homosexual men and women from entering the military. And those who were discovered in the military were discharged in proceedings that often left them seriously branded for life. With the advent of the Cold War, things got even worse. Fearful of domestic subversion, Americans turned with a vengeance against homosexuals. The conflation of communists and queers seemed only logical, for Americans viewed communism as atheist, unchristian, immoral, and degenerate. As one congressman asserted in 1950, the Russians are strong believers in homosexuality. Red-baiting journalists warned that communists are now converting American youth to homosexuality to defeat us from within. And Senator Kenneth Wary of Nebraska, the Republican floor leader, declared that, quote, "You can't hardly separate the homosexuals from the subversives." By 1950, the lavender scare, as it came to be called, was well underway. Government agencies began using lie detectors to determine whether their employees were homosexuals. The FBI compiled lists of suspected homosexuals from local vice squads, and President Eisenhower issued an executive order officially declaring sexual perversion a serious security risk. In light of the intensity of the anti-homosexual fever that gripped the nation during the lavender scare, gays and lesbians found themselves increasingly isolated. In a society in which the dominant religion excoriated homosexuality as a heinous sin, the law branded it as a vicious crime, and the medical profession diagnosed homosexuals as diseased, the vast majority of individuals who harbored homosexual impulses did their best to hide their secret shame from family, friends, neighbors, employers, and associates. The terrible fear of discovery kept the secret lives of most homosexuals invisible even to one another. Indeed, even civil rights groups turned their backs on gays and lesbians in this era. In 1957, for example, the National Board of the American Civil Liberties Union declared that, quote, "It is not within the province of the ACLU to question the validity of laws aimed at the suppression or elimination of homosexuals." By the late 1960s, though, inspired by the civil rights and women's rights movements, a small handful of courageous gay men and lesbians began calling openly for the acceptance of homosexuals as equals in society. In 1969, for example, Carl Whitman, a gay SDS leader, penned what he termed the Gay Manifesto, in which he declared, quote, "Our first job is to clear our own heads of the garbage that's been poured into them. Liberation for gay people is defining for ourselves who we are. It is time for us to come out." This was the first time that anyone had used the term "come out" in this manner. For those who sought equal rights for gays and lesbians, coming out was a radical, daring, and dangerous act that would affect every aspect of their lives. Indeed, as late as 1969, only a few hundred members of the growing gay rights organizations in the United States had publicly identified themselves as homosexuals. But this was about to change. At around 1 a.m. on the night of Friday, June 27, 1969, the New York police raided the Stonewall Inn, a dingy, mafia-owned gay bar on Christopher Street in Greenwich Village. 5 other New York bars had been raided in the previous 3 weeks, but this time the drag queens, bar boys, and lesbians who'd been either in the bar or in the gathering crowd outside resisted the police harassment. The next night, hundreds of gay men and women gathered on Christopher Street, leading to yet another confrontation with the police, an event that generated national attention. A year later, thousands of people commemorated the anniversary of Stonewall by marching in New York City, Chicago, and Los Angeles in the nation's first gay pride parades. The decade after Stonewall saw gradual but halting progress in the cause of gay rights. In 1972, a lesbian was allowed to retain custody of her own children in a contested divorce for the first time in American history. In 1973, the American Psychiatric Association declared for the first time that homosexuality was not a mental illness. And by the end of the decade, 22 states, adopting the recommendation of the American Law Institute, had repealed their laws making consensual sodomy a crime. Illinois, by the way, was the first state in the nation to do this. These developments sparked a sharp backlash, however. The most dramatic explosion arose over a proposed gay rights ordinance in Dade County, Florida. In 1977, the county commission, following the lead of several other cities, passed an ordinance prohibiting employment discrimination on the basis of sexual orientation. Local religious groups were outraged and demanded an immediate repeal of the ordinance. Local Baptists charged that the law violated God's biblical commandments, and the National Association of Evangelicals soon entered the fray. Leaders of the Christian right, including Jerry Falwell, Pat Robertson, and Jim and Tammy Baker, came to Miami to campaign in favor of repeal. And in the special referendum, Dade County's voters repealed the ordinance by an overwhelming margin. This victory generated momentum for a new religion-based anti-gay movement. The campaign took on an ugly tone as bumper stickers appeared across the nation with such messages as "Kill a queer for Christ." Within 2 years, many of the laws that had been enacted in other cities to protect gays from discrimination were also repealed. The Christian right charged that such laws promoted child molesting and gay recruiting, and the Reverend Jerry Falwell raged that homosexuals do not reproduce, they recruit, and many of them are after your children. The anti-gay rights crusade saw this fight as a religious battle for the Christian soul of America. Soon thereafter, AIDS struck the gay community with a vengeance. As the disease became associated in the public mind with homosexuality, the Christian right deemed AIDS God's punishment for homosexual sodomy. The Reagan administration, which had actively courted the Christian right, had no interest in devoting government time or money to an illness that was thought to threaten only gay men. Rather than invest federal funds in medical research, the White House instructed the Center for Disease Control to, quote, "look pretty and do as little as we can." Over the course of the next decade, AIDS ravaged the homosexual community, killing more than 250,000 gay men, and leaving hundreds of thousands more to wonder if they might be next. Ironically, though, the horror of AIDS brought homosexuality into the light. As thousands of gay men died horrible deaths, people had to take notice, often, though not always, with sympathy and concern. Gradually, one person at a time, in often awkward and sometimes excruciatingly painful conversations with family, friends, and acquaintances, the previously closeted lives of homosexuals became visible, first out of necessity and desperation, and later out of candor and self-respect. Gay invisibility was suddenly melting away. At the Gay and Lesbian March on Washington in 1993, hundreds of thousands of individuals wearing pink triangles marched proudly past the White House. I should say, by the way, that I happen to know that because I was there. I'll also share with you a story which I've never told publicly before. The reason I was there was not because of the march. I was there because it happened to be a reunion of the law clerks of Justice Brennan. And However, the existence of the march was well known, and so I participated in it on my way to the White House, on the way to the Supreme Court for the reunion. And after getting there, gathering with about 60 of Brennan's clerks and Justice Brennan, we were in the chamber of the Supreme Court, and the American flag is standing right next to the bench where the justices sit. And it occurred to me that I should do something. And so I took one of the buttons, like this one, and my then wife, Nancy, while I kept guard, pinned it onto the red stripes on the American flag in the Supreme Court. To the best of my knowledge, it's still there. I've never revealed this crime before. In any event, 4 years after the 1993 march, Ellen DeGeneres, star of the popular ABC television show Ellen, came out as a lesbian. And shortly thereafter, some 42 million viewers tuned in to watch DeGeneres' character, Ellen Morgan, reveal that she too was a lesbian. It was a remarkable moment, but not everyone cheered. The response of the Christian right was fierce. The Reverend Jerry Falwell called Ellen DeGeneres Ellen Degenerate, and the Southern Baptist Convention called for a boycott of ABC because it had dared to broadcast the show. In the view of the Christian right, homosexual perversion, immorality, and degeneracy were now being spewed across the land. Donald Wildman, the president of the American Family Association, railed that homosexuality was a sin, grievous to God, and repulsive to Christians. This struggle, he declared, was a matter of life and death, because if we fail, we fear the judgment of God on our nation. The battle lines had clearly been drawn. So this brings me back to the Supreme Court. As we saw earlier, in its first encounter with homosexuality, the Supreme Court had held in Bowers versus Hardwick that a state could constitutionally make homosexual conduct a criminal offense. The court explained that given the history of religious and moral condemnation of homosexuality, any suggestion that the Constitution could be interpreted as protecting such behavior was, quote, at best, facetious. The court's second foray into this arena was Romer versus Evans, which was decided in 1996, exactly a decade after Bowers. As I noted earlier, beginning of the late 1970s, several cities enacted ordinances prohibiting discrimination on the basis of sexual orientation. As in Dade County, however, this generated a sharp response from the Christian right, which usually succeeded in getting those laws repealed. In Colorado, after Denver enacted an anti-discrimination ordinance in 1991, a coalition of Christian right organizations launched an aggressive campaign to amend the Colorado Constitution to override the ordinance. Amendment 2, which was adopted in a statewide referendum, provided that neither the state of Colorado nor any of its subdivisions could enact any law that protected homosexuals against discrimination. 9 days later, lawyers from Lambda Legal and the American Civil Liberties Union, which by now had changed its tune, filed suit claiming that Amendment 2 violated the United States Constitution. In light of Bowers, it seemed clear that the Supreme Court would reject the challenge. But in a stunning 6-3 decision, the court held Amendment 2 unconstitutional. Justice Anthony Kennedy, who'd been appointed to the court by President Ronald Reagan, of all people, authored the court's opinion. In Kennedy's view, the problem with Amendment 2 was that it imposed a special disability only upon homosexuals. This was so, he said, because under Amendment 2, every group in Colorado was free to try to persuade a city council, a state university, the state legislature, to enact a rule or a regulation or a law that would protect them against discrimination, except for homosexuals. Because of Amendment 2, only homosexuals would have to amend the state constitution before they could obtain protection against discrimination from some agency in the state. With that fact in mind, Justice Kennedy turned to the Equal Protection Clause of the 14th Amendment, which provides, quote, that no state shall deny to any person the equal protection of the laws. Under that guarantee, if a law treats some people differently than others, ordinarily it will still satisfy the demands of equal protection if it bears even a rational relation to some legitimate end. Although almost every law passes that highly deferential standard, Justice Kennedy concluded that Amendment 2 did not. This was so, he reasoned, because a law declaring that it shall be more difficult for one group of citizens than for all others to seek aid from the government was virtually unprecedented in American history. And it was therefore impossible to escape the inference, he explained, that the disadvantage imposed on homosexuals by Amendment 2 was the result not of any rational effort to further a legitimate state interest, but of animosity and antagonism towards the class of persons affected. Because a bare desire to harm a politically unpopular group cannot constitute a legitimate government interest, Kennedy concluded that Amendment 2 violated the Equal Protection Clause. Justice Antonin Scalia, joined by Chief Justice Rehnquist and Justice Clarence Thomas, was of a rather different view. Scalia maintained that Amendment 2 is not a manifestation of a bare desire to harm homosexuals, but is rather a rational and perfectly legitimate attempt by Coloradans to preserve traditional sexual mores. He castigated Justice Kennedy's reasoning as utterly disingenuous and as inconsistent with Bowers versus Hardwick. The Supreme Court's third decision involving the rights of homosexuals, Lawrence versus Texas, was pretty much a rerun of Bowers versus Hardwick. Police officers in Houston were dispatched to a private residence in response to a reported disturbance. After they entered the residence, they saw two men engaging in anal sex. The men were arrested, charged, and convicted of violating a Texas statute, making it a crime for any person to engage in deviant sexual intercourse with another individual of the same sex. Since 1982, Bowers versus Hardwick had been used by politicians, legislators, and judges to justify discrimination against gays and lesbians in deportation hearings and adoption proceedings, in military discharges, in employment discrimination, and in a host of other contexts. After all, if homosexual conduct is criminal, then a homosexual is no different than a rapist, a robber, or a thief. But much had changed in the 17 years between Bowers and Lawrence. Not only had AIDS devastated the gay community and changed the public's perception of homosexuality, but 60% of Americans now thought that homosexual sex should no longer be deemed a criminal offense. In a 6-3 decision, the Supreme Court overruled Bowers v. Hardwick and held the Texas statute unconstitutional. Justice Kennedy again delivered the opinion of the court. Kennedy maintained that the court's reasoning in Bowers versus Hardwick had been distorted by its failure to appreciate the extent of the liberty at stake in such deeply personal relationships. Although conceding that the framers of the Constitution had not expressly guaranteed the right to engage in homosexual sex, Kennedy explained that the framers had intentionally left some constitutional guarantees open-ended because they knew that later generations can see that laws once thought to be proper serve, in fact, only to oppress. That, Kennedy maintained, was the situation in Lawrence. There was, he concluded, no constitutionally legitimate justification for making same-sex sex a crime. Justice Scalia, joined once again by Rehnquist and Thomas, dissented. Scalia accused the court of signing on to what he termed the homosexual agenda, and he fumed that the court had no business in validating legislation that had been legitimately enacted by the citizens of Texas. Echoing Justice Scalia's outrage, religious conservatives throughout the nation were livid. Pat Robertson denounced the court for rending the moral fabric of the nation. Jerry Falwell warned that Lawrence would lead to bestiality, and a pastor in Kansas fumed that it marked the death knell of American civilization. When it came time for Justice Anthony Kennedy to announce the judgment of the court in Lawrence, he read a brief statement explaining the result from the bench. The Supreme Court chamber was, of course, packed. Sitting there on the flag was that pin, by the way. At the end of his statement, Justice Kennedy declared, quote, "Bowers v. Hardwick was not correct when it was decided, and it is not correct today. It ought not to remain binding precedent. Bowers v. Hardwick should be, and now is, overruled." It was a remarkable moment. Overwhelmed by what was happening, many of the gay and lesbian advocates sitting in the gallery sobbed openly. For the gay and lesbian community, it was an occasion for dancing in the streets. Joyous demonstrations erupted in cities across the nation. For gays in America, Lawrence meant much more than that rarely enforced anti-sodomy laws could no longer be legally enforced. Rather, this chokes me up, I'm sorry. Rather, Lawrence meant that never again would their rights be dismissed, but the highest tribunal in the land as, at best, facetious. And never again would they wonder whether the words engraved, I believe in law, you see. And never again would they wonder whether the words engraved on the pediment of the Supreme Court building, equal justice under law, included them. The Constitution was now their Constitution as well. In San Francisco, a group of veterans who had been expelled from military service during World War II because of their sexual orientation proudly saluted as a huge rainbow flag which had flown atop an 80-foot pole for more than 5 years was lowered, and the American flag for the first time was raised in its place. Okay, done with that. Okay, for most of American history, the notion that a man could marry a man or that a woman could marry a woman seemed utterly absurd. In 1990, however, only 4 years after Bowers versus Hardwick, 3 gay couples in Hawaii applied for marriage licenses, which were, of course, denied. Audaciously, they then filed suit in the state court, claiming that the state's refusal to allow same-sex couples to marry violated the Hawaii Constitution. To pretty much everyone's shock, the Hawaii Supreme Court ruled in 1993 that the state law restricting marriage to a man and a woman might possibly violate the Hawaii Constitution. This decision provoked a furious response from the Christian right, and almost immediately states across the nation rushed to amend their state constitutions explicitly to define marriage as involving only one man and one woman. The goal of these amendments was both to prevent their own state courts from ever following the Hawaii Supreme Court's suggestion, and to make it impossible for future majorities in their state, should they ever emerge, to legalize same-sex marriage by enacting legislation to that effect. If they wanted to do that, they would now have to re-amend the state constitution. These issues played out at the national level as well. As the 1996 election approached, the anti-gay rhetoric was virulent. Dick Armey, the Republican whip in the House, publicly referred to Congressman Barney Frank as Barney Fag. 6 of the 7 Republican presidential candidates vehemently condemned the idea of same-sex marriage, and Republican Speaker of the House Newt Gingrich proposed the Defense of Marriage Act, or DOMA, which provided, among other things, that if any state recognized marriages between persons of the same sex, persons entering into such marriages would be ineligible for the multitude of federal benefits that were otherwise available to married couples. The hearings on DOMA were openly homophobic. Members of Congress described gays and lesbians as sick, as perverted, as dangerous, charged that the nation was facing a dangerous attack upon God's principles, and warned that the flames of hedonism are licking at the foundations of our society. Congress quickly enacted the legislation, and with the presidential election just around the corner, and with the American people opposed to same-sex marriage at the time by a margin of 68 to 27%, President Bill Clinton promptly signed DOMA into law. Of course, none of this really mattered at the time because same-sex marriage was not legal in any state in the nation and was not likely to be. But 7 years later, in 2003, the Massachusetts Supreme Court held that laws denying same-sex couples the freedom to marry violated the Massachusetts Constitution. Massachusetts thus became the first state in the nation to legalize same-sex marriage. In response, 13 additional states promptly amended their state constitutions to forbid same-sex marriage ever. Several years later, though, the state Supreme Courts of Connecticut, California, and Iowa followed Massachusetts' lead and held that their state constitutions also guaranteed same-sex couples the freedom to marry. Moreover, in 2009, Vermont became the first state in the nation to enact same-sex marriage by legislation. And shortly thereafter, New Hampshire and Maine followed suit. But the pushback, again, was furious. In Maine and California, for example, the Christian right launched vigorous and successful campaigns to amend their state constitutions to outlaw same-sex marriage and to obliterate either the legislation or the state Supreme Court decisions. And voters in Iowa, spurred on by the moral majority, voted out of office 3 of the state Supreme Court justices who had voted to recognize a state constitutional right to same-sex marriage. As the executive director of the American Family Association warned, if any judge attempts to impose an amoral agenda on us, we are going to take you out. Thus, despite several seemingly landmark victories, the movement for same-sex marriage had stalled. DOMA remained the law nationally. Most efforts to legalize same-sex marriage had been overturned, and by 2013, more than 30 states had enacted state constitutional amendments expressly outlawing same-sex marriage. So this brings me to the Supreme Court's fourth and most recent decision in our story, United States versus Windsor. Edith Windsor and Thea Spire met in New York City in 1963 and began a long-term relationship. In 2007, they were married in Ontario, Canada, and New York law recognized the validity of their marriage. 2 years later, Spire died, leaving her estate to Windsor. When Windsor sought to claim the federal estate tax exemption for surviving spouses, she was, of course, barred from doing so by Section 3 of DOMA, which expressly provided that no provision of federal law could recognize as lawful any marriage other than those between a man and a woman. Windsor then filed suit challenging the constitutionality of Section 3. In a bitterly divided 5-4 decision, the Supreme Court invalidated Section 3 of DOMA on June 26, 2013, 10 years to the day after its decision in Lawrence. As in Romer and Lawrence, Justice Anthony Kennedy again authored the opinion of the court. He was joined by Justices Ginsburg, Breyer, Sotomayor, and Kagan. Chief Justice Roberts and Justice Scalia, Thomas, and Alito dissented. In his opinion for the court, Justice Kennedy explained that the issue presented was not whether states were constitutionally obligated to recognize same-sex marriage, but whether the federal government could constitutionally discriminate against couples who were legally married in a state because those individuals happened to be of the same sex. In approaching this question, Kennedy emphasized that by history and tradition, the definition and regulation of marriage has been treated as being primarily within the authority of the states. A state's decision to give same-sex couples the right to marry, he noted, conferred upon them a dignity and a status of immense import. Although acknowledging that Congress, in enacting specific statutes, can make determinations that bear on marital rights and privileges, Kennedy characterized DOMA as unprecedented because it applied to over 1,000 federal statutes and to the whole realm of federal regulations. Thus, like Colorado's Amendment 2, which had been invalidated in Romer, Kennedy maintained that a central purpose of DOMA was to undermine the equal dignity of gays and lesbians. Indeed, DOMA's principal effect, he maintained, is to identify a subset of state-sanctioned marriages and to make them unequal. By creating two contradictory marriage regimes within the same state, DOMA, he reasoned, places same-sex couples in the position of being in a second-tier marriage, a discrimination that demeans the couple and humiliates tens of thousands of children now being raised by same-sex couples. Because no legitimate federal interest justified what he described as the purpose and effect of disparaging those whom the state has sought to protect, Kennedy concluded that DOMA violated the United States Constitution. In a furious dissenting opinion, Justice Antonin Scalia characterized the court's reasoning as nothing short of remarkable. At various points, Scalia dismissed Kennedy's analysis as, quote, perplexing, confusing, absurd, overcooked, and legalistic argle-bargle. Scalia reiterated what he had insisted upon in Lawrence. The Constitution, he said, does not forbid the government to enforce traditional moral and sexual norms. That, in itself, he maintained, is sufficient justification for the federal government's decision not to recognize same-sex marriages. Scalia angrily predicted that Windsor would lead to recognition of a constitutional right to same-sex marriage. He charged that if the court believed that DOMA was the product of unconstitutional animus against homosexuals, then surely it would make the same assertion about state laws limiting marriage to one man and one woman. As far as this court is concerned, he fumed, no one should be fooled. It is just a matter of waiting for the other shoe. It is striking how far the court had moved in the 27 years from Bowers to Windsor. This was due to several factors, one of which was not an overall move of the court in a generally more liberal direction. To the contrary, on a broad range of issues, including affirmative action, campaign finance, gun control, and voting rights, the court, with the additions of Justices Scalia, Kennedy, Thomas, Roberts, and Alito, had grown, if anything, notably more conservative than the court at the time of Bowers. What had changed in those years was the public awareness of gays and lesbians in society, and the public and legal understanding of both the morality and wisdom of laws discriminating on the basis of sexual orientation. Indeed, public opinion on these issues had shifted dramatically between Bowers and Windsor. In 1986, no one had even thought to poll on the question of same-sex marriage. It wasn't until 1996 that Gallup finally thought to ask people this question, and at that time, only 27% of Americans thought same-sex marriage should be legal. But by 2013, when Windsor was decided, 54% of Americans shared that view. This shift was due to many factors, but most important was the profound change in the visibility of gays and lesbians in American society. This transformation affected not only everyday citizens, but also legislators, mayors, governors, presidents, judges, and justices of the Supreme Court. With these changes, the traditional judicial understandings of such fundamental legal concepts as liberty, equality, and due process, as applied to homosexuals, were suddenly called into question, and rightly so. It's important to note, though, that these changes in public attitudes and understandings did not in themselves dictate any particular constitutional change. Bowers and Windsor were both 5-4 decisions. Only one vote had changed over the course of those 27 years. Had Robert Bork been confirmed by the United States Senate, and Anthony Kennedy therefore never been appointed to the court, the outcome in Windsor almost surely would have been 5-4 the other way. As I said earlier, I am a great believer in serendipity. The point is that the divergent outcomes in these cases were shaped by at least two critical factors: the general public understanding of homosexuality at the time of the decision, and the particular interpretive approaches and values of the individual justices who happened to be on the court at the specific moment when the issues arose. Since Windsor, there has been a virtual avalanche of lower court decisions invalidating state laws denying same-sex couples the freedom to marry. Before Windsor, the vast majority of all courts and judges who addressed this issue held that laws limiting marriage to opposite-sex couples were constitutional. But in the 2 years since Windsor, the overwhelming majority of courts and judges have held such laws unconstitutional. The shift has been sudden, and it has been seismic. The other shoe is indeed about to fall. In June, the Supreme Court will hand down its decision in Obergefell versus Hodges, which directly presents the question whether state laws that deny same-sex couples the freedom to marry violate the United States Constitution. It seems almost certain that at least 5 justices will now take this step, and that Justice Anthony Kennedy will in all likelihood write the opinion of the court, a privilege that he's earned. What is unknown is whether any of the other justices will join that decision, and what explanation the court will give for its decision. Now, the latter is especially intriguing, because despite Romer, Lawrence, and Windsor, it remains a bit of a mystery how the majority thinks about these questions in terms of doctrine. Justice Scalia's criticisms of the court from this standpoint has some merit. The central question is whether laws denying same-sex couples the freedom to marry violate the Equal Protection Clause of the 14th Amendment. Those advocating this position have advanced 3 primary arguments in support of their view. First, they argue that laws denying same-sex couples the freedom to marry are unconstitutional because they do not rationally further a legitimate state interest, that the real purpose of such laws is to denigrate and stigmatize a despised class of citizens, and that like the laws invalidated in Romer, Lawrence, and Windsor, these laws therefore violate the Equal Protection Clause. Those on the other side point out that the rational basis standard is a highly deferential one. And they argue that there are, in fact, legitimate justifications for laws that limit marriage to one man and one woman, including morality, tradition, promoting procreation, promoting family stability, and preserving respect for the institution of marriage. Moreover, they argue that even if the court was right to find evidence of animus in Romer and Windsor because of the unprecedented nature of the laws at issue in those cases, no similar inference can logically be drawn with respect to the traditional understanding that marriage involves a relationship between a man and a woman. After all, they argue, when marriage was defined in that way many, many centuries ago, no one was thinking about homosexuals one way or the other. That being so, they reason, animus toward homosexuals has nothing at all to do with the traditional definition of marriage. The second argument advanced by those challenging the constitutionality of laws denying same-sex couples the freedom to marry turns on the notion that the freedom to marry is itself a fundamental interest. Now, in a series of decisions over the past century, the Supreme Court has held that a law that treats people differently with respect to a fundamental interest, such as the right to vote, the right not to be sterilized, or the freedom to use contraceptives, violates the Equal Protection Clause unless it satisfies something called heightened scrutiny. That is, when a law treats people differently with respect to a fundamental interest, the law is unconstitutional unless it substantially furthers an important government interest. A mere rational explanation is no longer sufficient. Those who challenge the constitutionality of laws denying same-sex couples the freedom to marry maintain that such laws implicate a fundamental right to marry, and that they therefore must pass heightened scrutiny review, a test that pretty much everyone agrees cannot be satisfied. Those who defend the constitutionality of laws denying same-sex couples the freedom to marry respond that even if the freedom to marry is fundamental, that applies only to opposite-sex couples. This is so, they argue, because for an interest to be recognized as fundamental, it must be deeply rooted in our nation's history, legal traditions, and practices. Although the right of opposite-sex couples to marry is clearly fundamental, under that standard, they insist that there is no analogous fundamental interest on the part of same-sex couples to marry, because that practice can hardly be said to be deeply rooted in our nation's history, legal traditions, and practices. In response, those arguing in favor of a fundamental right of same-sex couples to marry maintain that just as the meaning of express constitutional rights, like the freedom of speech or the freedom of religion, can evolve over time with changing circumstances, so too can the meaning of implied fundamental rights, like the interest in marriage, evolve over time. Okay, the third argument of those challenging the constitutionality of laws denying same-sex couples the freedom to marry is that because such laws discriminate on the basis of sexual orientation, they are analogous to laws that discriminate against individuals on the basis of race, national origin, gender, and similar characteristics, and that they therefore call forth heightened scrutiny under the Equal Protection Clause for that separate and distinct reason. Now, the Supreme Court has long held that laws discriminating against individuals on the basis of certain suspect criteria are especially problematic and are therefore unconstitutional unless they satisfy a much more demanding standard of justification. Because laws discriminating against African Americans are the paradigm violation of the Equal Protection Clause, the court generally considers four factors in determining whether discrimination against any particular group should be deemed suspect. Whether the group has experienced a history of invidious discrimination, whether the defining characteristic of the group is essentially immutable, whether the group can effectively protect itself against discrimination through the political process, and whether the discrimination is based on stereotyped characteristics that are not truly indicative of the group's ability to perform in society. Those who contest the constitutionality of laws discriminating against gays and lesbians maintain that such discrimination satisfies these criteria and therefore must be tested by heightened scrutiny. In response, those who defend the constitutionality of laws discriminating against gays and lesbians maintain that homosexuality is a choice, that what homosexuals call a history of discrimination therefore is no different than a history of discrimination against any other group of individuals who choose to violate society's moral norms and legal strictures, that gays and lesbians have ample political power, and that homosexuality is relevant to a host of legal considerations, most obviously to marriage. So in their view, laws that discriminate against homosexuals are no different than laws that discriminate against people who commit incest or burglary or assault or bestiality. Such laws, they insist, are completely different constitutionally from laws that discriminate against African Americans or women or Hispanics or Japanese Americans. So what should the court do? In my view, all three of these arguments would justify a decision invalidating laws forbidding same-sex marriage. And lower courts have in fact invoked all of them in one case or another in the past 2 years. My preferred rationale is the third, that laws discriminating against gays and lesbians are constitutionally suspect in ways that are similar to laws that discriminate against blacks, Hispanics, women, and to use the World War II example, persons of Japanese descent. Gays and lesbians have been subjected to a long history of invidious discrimination. Sexual orientation is not a matter of choice. Gays and lesbians have consistently had their interests dismissed and overridden in the political process, and sexual orientation has nothing to do with an individual's ability to perform in society. Put simply, and especially in light of our history, laws that expressly discriminate against gays and lesbians, whether in marriage, child custody disputes, employment, housing, or any other context, are properly understood as suspect in the sense that they are highly likely to be tainted by considerations of animus, hostility, ignorance, and prejudice. This, to me, is the deepest and truest reason for invalidating laws that discriminate against gays and lesbians. Moreover, unlike the marriage is a fundamental interest and the irrationality arguments, the suspect classification argument renders all government discrimination against gays and lesbians presumptively unconstitutional, as it should be. This argument cuts to the very heart of the issue and no longer skirts around the edges of the problem. It is my hope that the court will embrace this argument and thereby put government-sponsored discrimination against gays and lesbians to rest once and for all. I'd like to conclude with two final observations. First, perhaps foolishly, I am by nature an optimist. I tend to believe in progress, especially in the realm of discrimination. When we think back over the past 100 years, America has made great strides in addressing, though surely not solving, issues of discrimination based on race, gender, religion, and now sexual orientation. I am proud of the role that lawyers, law professors, and judges have played in helping this progress along. But it's important not to take this achievement for granted. 25 years ago, no one in this room would have imagined that the Supreme Court of the United States might hold that homosexuals had a constitutional right to marry one another. In truth, this prospect is remarkable. It's also important to understand the central role that courts have played in this process. As of now, same-sex marriage is legal in 37 states. But only 11 of those states have voluntarily chosen to legalize same-sex marriage by legislation. But for the role of courts, 39 states would still forbid same-sex couples to marry. Moreover, because almost all of those states have adopted state constitutional amendments forbidding same-sex marriage, even a majority of the citizens in those states could not legalize same-sex marriage through legislation, even if they wished to do so now or in the future. In such circumstances, the role of courts in interpreting and implying and enforcing the Constitution is essential. My second and final point looks to the future. For most of American history, religion controlled the law in the United States on issues like sexual expression, contraception, abortion, and homosexuality. Traditional Christian values dictated the content of our laws. In the last half-century, though, due largely, though surely not entirely, to the Supreme Court, those Christian values have increasingly been pushed aside, and individuals have been freed to act on their own personal and religious beliefs rather than being dictated to by the religious beliefs of others. This is a great achievement in a society dedicated to the separation of church and state. But it now leaves us with a really interesting and intriguing challenge. For our Constitution also guarantees the freedom to practice one's religion. And with the demise of the religious state, those who hold to traditional Christian values often find themselves now on the defensive. No longer able to dictate that others must act in accord with their religious beliefs, they now demand that they be permitted to act in accord with their own beliefs. Hobby Lobby demands the right not to provide certain contraceptives to its women employees. Catholic priests demand the right not to have to marry same-sex couples. And florists, bakers, hotel owners, and restaurant owners demand the right not to participate in same-sex weddings in the face of laws prohibiting discrimination on the basis of sexual orientation. These are not easy questions for one who values both the separation of church and state and the freedom of religion, as I do. But those, happily, are questions for another day. For now, we are where we are. And we are, quite simply, on the threshold of an exciting new era in human dignity. I can't wait to see the celebrations. Thank you. Thank you. Thank you. So I will be happy to take questions. There are people with microphones, is that correct?
Yes.
Yes, there are. So if you have a question, raise your hand, and the person with the microphone will somehow or other get it over to you.
Jeff, I'm a bit puzzled by the confidence of the predictions about Kennedy in the upcoming case. I thought in Windsor, he was motivated largely by his stance on federalism, and the decision turned importantly on the fact that the state of New York already had accepted gay marriage. The predictions would seem to be an anti-states' rights conclusion for Kennedy, which strikes me as very much against his commitment to allowing marriage to be defined locally. So that's why the confidence, many of the decisions that have come down since Windsor actually have seemed to me to overinterpret or sort of avoid the central position that he was articulating there, which was leave it to the states and then the federal government can't interfere.
Exactly right, up to a point. If one takes the opinion in Windsor literally, Kennedy was being very careful to say that we are not dealing with the issue of whether individuals have a constitutional right to same-sex marriage vis-a-vis the states. No question, it's a federalism opinion, it's dressed up in that way. And Chief Justice Roberts, in response to Scalia's claimed that this is going to lead inevitably to the constitutional right to same-sex marriage, Chief Justice Roberts takes the position you just stated and says, wait, don't panic, Nino. It's not that bad, it's not going to happen so fast, don't worry about it. I think the reality, though, is that Justice Kennedy was doing what lawyers often do, which is being incremental and deciding only the case before him. And he did not need to address anything about the question about whether there's a constitutional right to same-sex marriage vis-a-vis the states in Windsor. But I think it's also the case that people who understand Anthony Kennedy understand that he's been waiting for years to be the hero in this respect. Because he believes this. I mean, it's sincere. But he, I think, has wanted to be the one who writes this opinion, who writes the equivalent of Brown v. Board of Education. This will be his legacy. And I think he sincerely believes that. So he wrote a careful opinion in Windsor. He addressed only the issue before him. But I think people who know Kennedy and understand his views about these issues are almost as confident about his vote in this case as they are about Ginsburg and Kagan and Sotomayor and Breyer. And there's more than that. The decisions of the lower courts that recognized a right of same-sex marriage in state after state after state, right? The Supreme Court refused to stay those decisions, therefore allowing individuals to get married in those states, in state after state after state, right? That would be truly a reckless and irresponsible thing for the Supreme Court to do if they were going to not recognize a right to same-sex marriage, because they would be creating a nightmare situation in which now you have these people who are married under the authority of a lower court decision finding a constitutional right to marry, and the Supreme Court that says, no, sorry, there is no right to marry. And now what happens, right? So those reading the tea leaves say that if there were really any serious doubt about what the court was going to do in this case, they would have stayed those decisions and therefore said, no one can act upon those decisions until we resolve this case that's now before us. The fact that they didn't do that is a very large cue as to what they're thinking. So it's not impossible that your suggestion is right, and it's a good lawyer's, even though you're not a lawyer, it's a good lawyer's reading of the opinion. But I think it's not going to be what happens. I'd be shocked, personally. Because the more interesting question is if Roberts were to join the majority and assign himself the opinion and try to write a very narrow opinion somehow. That would be a scenario in which they might find some way to do that, but I doubt that also. Yes? Hi.
Jeff, in my field, there's a law that states for every action there is an equal and opposite reaction. As far as I know, that's not subject to judicial review. But if you would, as a law professor, put your hat on and look at the other side and say, and speculate what the religious right will do on July 1st.
So the most interesting question of the pushback here will be whether there are some states which will say to the court, screw you. We are not going to comply, right? We will not recognize the legality of same-sex marriages. We will prohibit those people in the state who are authorized to perform same-sex, who are authorized to perform marriages, to perform same-sex marriages, and we will not give any benefits to anyone who is same-sex in marriage. And it will be a little bit like what happened after Brown and Board of Education, in which you will have, and I'm not predicting this will happen. This is the sort of worst-case scenario, right? Is that you'll have some states who will basically say, we are not going to comply, and they're going to be standing, if not in the schoolhouse door, in the chapel door, and you'll have governors saying, over my dead body, and that will be a mess. That could be a real mess, because compelling the states to recognize marriages is a very difficult procedural act, and you don't want to have to send in the National Guard. I mean, who are you going to send them against, right? So that's the worst case scenario. I don't think that will happen, because basically it would be Republican states that do that, and for the National Republican Party, that would be a disaster. And so my guess is that the National Republican Party will tell the people in states who would want to do that, don't do that. That would be a disaster for the National Republican Party. So my guess is that won't happen, but that is possible. And it could be another 10 years of fierce battle to compel states to recognize the legitimacy of same-sex marriages when they simply say, no, we're not going to do it.
I have a question about the causal structure of this remarkable story. It seems to me that although the courts have played a leading role, the law has not. That is, the law was lying there waiting to be interpreted, the separation of church and state, equal treatment before the law. And what was really driving this was an unprecedentedly fast change of public attitudes, which then pushed the courts to reinterpret the law that already existed. Is that accurate?
As I said, I think both factors were present. I mean, I don't think that the court would have gone as far and as fast as I think it will and has if it weren't for the fact that public opinion had shifted over these years. I mean, if we were still operating in the social culture of the 1960s or the 1950s, the Supreme Court would never be doing any of this stuff. No question about that. So the change in public attitudes is an important reinforcing factor in what the court feels it can appropriately do and what it thinks the Constitution should mean. I mean, in that sense. At the same time, I think that if we left this entirely to the political process, it would take another 40 years to get to the point where we're going to get in June. And that's the key difference. Thank you very much. Thank you.